Welcome, everyone. We are live with another episode of Level Up Law, where every Tuesday at noon, South Carolina Legal Services is leveling up your legal knowledge about an area of law that we practice in. And we also often, from time to time, bring in our partners and others to talk about what they're doing in the legal world. Today, we have with us Ms. Holly Webster, who is an excellent staff attorney here in the Greenville office. And I'm Susan Ingalls, the host of Level Up Law, and we have Kenneth Elliott with us as always, helping us with our technology. Today, we're going to be talking about assistance animals and direct threats under the Fair Housing Act. And Holly is particularly knowledgeable in the area of housing because she is an Equal Justice Works Housing Justice Program Fellow. So housing is all she does here at Legal Services. She does a terrific job of it. So we're glad to have her on the show. But before we get started, Holly, we are going to let our audience know that this is not legal advice. As always, we want to let folks know this is just legal information, general information for that matter, for the public, so that you'll kind of know what's out there when it comes to a particular legal topic and when you might need a lawyer, but also just general information so you can have a foundation of knowledge before you even talk to a lawyer. So hopefully this will be a really great opportunity for folks to learn about this topic. I do want to let you know that the presentation is being recorded and it will be uploaded to our YouTube channel at SC Legal Services on the Level Up Law playlist. So you can look for it there if you want to review. And we appreciate everyone being here, whether you are live or on the replay on YouTube. And so now we are going to go ahead and get started with lions and tigers and bears. Oh my. Take it away, Holly.
Thank you, Susie. So like Susie said, today's presentation will be on a look at assistance animals and direct threats under the Fair Housing Act. And just to start off, I'm going to run through what I'll be discussing during this presentation. So I'll be talking about the rule on accommodations, the direct threat exception, application to assistance animals regarding unique animals, breed and weight rules, the one bite policy, and landlord liability and insurance. Included is primary guidance throughout this presentation that I'll be referring to, HUD notice, and a HUD and Department of Justice joint statement on reasonable accommodations. So just starting out, it's important to note that the Federal Fair Housing Act prohibits the refusal to make reasonable accommodations in rules, policies, practices, or services when such accommodations may be necessary to afford a person with a disability the equal opportunity to use and enjoy a dwelling. However, a request for reasonable accommodation may be denied by a provider, a housing provider, if providing the accommodation is not reasonable. One example of this may be where the accommodation would impose an undue financial and administrative burden on the housing provider, or fundamentally alter the nature of the provider's operations. It is important to note that this determination by the provider must be made on a case-by-case basis, considering various factors like the cost of the accommodation, the benefits that it would provide to the requester, the financial resources of the provider, and the availability of alternative accommodations that would effectively meet the requester's disability-related needs. So regarding a direct threat exception, we look at another example where an accommodation may be considered not reasonable. And that would be where it poses a direct threat or results in substantial physical damage to property. It is important to note that the provider should use reliable and objective evidence when making this determination, as opposed to fear, speculation, or stereotypes. In making their determination, the provider must consider, 1, the nature, duration, and severity of injury, 2, the probability that injury will actually occur, and 3, whether any other reasonable accommodations will eliminate the direct threat. And I will discuss this more in later slides. So what are assistance animals? Well, assistance animals are accommodations for disabled persons who need them because of their disability. There are also, it's important to note, 2 types of assistance animals, and that's service animals and then other trained or untrained animals that do work, perform tasks, provide assistance, and or provide therapeutic emotional support for individuals with disabilities, also referred to as emotional support animals. So what is a service animal? Well, any dog that is individually trained to do work or perform tasks for the benefit of an individual with a disability. Okay, so we're looking at whether this animal is a dog and whether it is trained to do work or perform tasks for the benefit of an individual with a disability. And permissible questions by a provider in just considering whether a dog in this case is a service animal or whether an animal in being proposed as an accommodation is considered a service animal would be, is this animal required because of a disability? And then what work or task has the animal been trained to perform? Like I noted earlier, support animals are the other animals that do work, perform tasks, and provide assistance and or provide therapeutic emotional support for individuals with disabilities. This animal does not have to be a dog. It can be any other animal commonly kept in households. Here we have examples like cats, gerbils, rabbits, hamsters, small birds, even turtles. But kangaroos, monkeys, reptiles other than turtles, those are not considered common household animals. In trying to determine, you know, are assistance animals pets? Well, the answer is no. So this means that the housing provider cannot charge a pet fee. But if the animal is an assistance animal, that does not prevent a housing provider from charging a tenant for any damages caused by this assistant animal. If it is the housing provider's usual practice to charge tenants for damages caused by the tenant or deduct it from their security deposit. Although a housing provider may not limit the breed or size of a dog used as a service animal or support animal just because of the size or breed, they can, however, limit the breed or size of the dog based on specific issues with the animal's conduct, like if it poses a threat or fundamental alteration. So in looking at a direct threat as a limitation on assistance animals, it is important to not only consider the risk, but also the probability that the risk will even occur, and whether there are reasonable ways to significantly reduce or eliminate the risk. So in looking at Roe v. Sugar River Mills Associations, We see a case where a tenant files an action against an apartment complex and its managing agent, alleging that their conduct toward him violated the Fair Housing Act. The defendants in this case argued that the act did not apply, as the defendant was a direct threat to the health and safety of other tenants, describing his behavior as threatening, confrontational, and harassing. Defendant's response to this was that his outbursts were due to his mental disability, and that the defendants had a duty to explore whether a reasonable accommodation could have been taken to eliminate or minimize the impact of its disability on the other tenants. The court agreed, assuming that the tenant had a disability. The court determined that the act required the defendants to demonstrate that no reasonable accommodation would have eliminated or acceptably minimized the risk the tenant posed to other residents before they could fully evict, which best affirms the intent to eliminate housing discrimination, as you see on the slide, discrimination based on stereotypes, prejudice, or irrational fear. In contrast to the previous case, we look at a request, to the previous example, sorry, a request for an animal as an accommodation can be denied where evidence demonstrated that the specific animal poses a threat that cannot be mitigated. So in looking at this next case, Gill Terrace Retirement Apartments, Inc., v. Johnson, we have a landlord filing an eviction action against a tenant who the landlord alleged has violated the no pet policy. Although the landlord granted the tenant's request for an accommodation, the request that this particular dog, named Duchess, be the tenant's reasonable accommodation was denied. The reason was because the landlord alleged that Duchess was aggressive, that she would lunge, flare up, rear on her hind feet, and bare her teeth. She would also go crazy when residents and other dogs passed by. The other residents were afraid of Duchess and would stay indoors to avoid her. The tenant also testified that due to medical problems, she was not sure she could even restrain Duchess. At one point, even mentioning how she was fearful of Duchess, well, noting that Duchess would likely attack someone should they come in. This led the trial court to rule in favor of the landlord, although the tenant appealed. The trial court decision in this case was affirmed. So what about unique animals? So here the burden is on the requester to demonstrate a disability-related therapeutic need for this specific type of animal. So we have an example here of a capuchin monkey that performs tasks for a person with paralysis caused by a spinal cord injury. The monkey was trained to retrieve a bottle of water from the refrigerator, unscrew the cap, insert a straw, and place the bottle in a holder so that this individual can drink water. But in looking at Asenberg v. Anacortes Housing Authority, we see that the court determined that snakes were not a reasonable accommodation in this case because the tenant was not able to demonstrate a disability-related need and also didn't provide the information requested by the housing authority. You know, are these snakes, what types of snakes are these? Are they poisonous? To determine whether these snakes would be a threat to other residents. And also I want to note, in that case, I do remember, I believe the tenant was walking around and paying rent with the snake around his neck as well. So that was also something interesting. Just picture that. All right, so in looking at breed, height, weight, and restrictions, breed, height, weight restrictions, we look at Bogata v. Altamont Heights. Well, first looking at the fact that housing providers should not disqualify an animal based on breed, height, or weight without identifying problems with a specific animal that creates a threat or poses a substantial risk of physical injury to the premises. So in looking at Bogata v. Altamont Heights Condo Association, we see an Air Force vet with PTSD, stress, anxiety, and social interaction issues. Here, the condo association where he lived prohibited occupants from keeping dogs that weighed more than 25 pounds. However, the dog Mr. Bogata acquired weighed more than 25 pounds, but alleviated Mr. Bogata's psychiatric symptoms and helped him to manage his condition. The association demanded that Mr. Bogata remove Kane, which was the name of the dog, to which Mr. Bogata responded by providing 3 letters from his treating psychiatrist regarding his diagnosis and how Kane alleviated his symptoms. The association asked the following questions after receiving this information. They asked, what is the exact nature of your impairment? How does it substantially limit a major life activity? How long have you been receiving treatment for this specific impairment? How many sessions have you had with Dr. Lee? What specific training has your dog received? Why does it require a dog over 25 pounds to afford you an equal opportunity to use and enjoy your dwelling? And Mr. Bogata answered those questions, but then the association followed up with more questions and then instructed him to respond by a specified deadline or it would be forced to file arbitration against Mr. Bogata. So, instead of responding, Mr. Bogata filed a complaint with HUD and also sued the association in federal court. And in court, it was determined that the association's actions constituted a constructive denial of the accommodation request because of the requirement that if he did not answer the additional questions, that they would file basically retaliate against him. But he already answered questions that the court considered to be satisfactory, and so that's what that outcome was. And then Mr. Bogata was awarded both damages and attorney's fees. In contrast, we look at, in contrast with the previous case, we look at Wilkinson v. City of Arapahoe, where the court found that a specific dog Wilkinson wished to use as his accommodation was not necessary as related to Wilkinson's disability to enable use and enjoyment of the home. As Wilkinson had been disabled for 35 years, the court noted, and only had this particular dog he wanted to use as his accommodation for 2 years. In addition to that, Wilkinson also had another dog that he owned for almost 5 years and was not able to explain to the court or prove to the court why this dog he's had for almost 5 years could not provide comparable therapeutic benefit to Wilkinson with regard to his disability. And looking at the one strike policy for assistance animals, it's important to note that the direct threat analysis would still be required. So in the matter of Washington v. Alatoy, we have a New York City Housing Authority employee who was bit by an occupant's dog while delivering a hot plate. The occupant was issued a lease termination for having a vicious dog and failing to control and register or maintain their dog. The occupant requested an administrative hearing and informed the hearing officer of their diagnosed anxiety and depression and schizophrenia, having previously submitted a reasonable accommodation request related to the dog. That was both supported by a doctor and social worker letter regarding the diagnosis and need for the dog. However, in this case, the hearing officer still determined that the dog was vicious and ordered that it be removed without applying the direct threat analysis. On appeal, the order was reversed and remanded so that the hearing officer could conduct the direct threat analysis. Is there a reasonable accommodation that could have been put in place to prevent harm to others or reduce or completely get rid of the direct threat? So generally, a South Carolina landlord, in looking at liability concerns, is not liable for damages caused by a dog attack, even when a landlord knew of the dog's aggressive tendencies. So here, there are a few cases. Mitchell v. Basil is what we'll start out with, where the court stated that there was no authority that imposed vicarious liability upon a landlord for the injuries caused by a tenant's dog, or a theory of negligent rental or entrustment of land. And this was even despite the fact that the landlord knew the dog was vicious and had time to terminate the lease. In the next case, Fair v. United States, it was determined that there was no landlord liability for a dog bite under the landlord's duty to keep the premises fit and habitable. And then in Gilbert v. Miller, we see the court once again determined that there was no landlord liability for a dog bite pursuant to a pet policy that was designed to prevent damage to the property versus protecting parties and third parties insured by a tenant's dog. But in contrast to the previously mentioned examples, there was Clea v. Odom, where the landlord was held liable when a dog attacked a young child because the dog was tied to a tree in a common area, and landlords have a duty to keep common areas in a reasonably safe condition. The landlord in this case also was aware of the dog's tendencies because the dog had previously attacked another child. Regarding insurance concerns, 2006 HUD memo provides guidance on how HUD investigators should examine the Fair Housing Act reasonable accommodation cases where a housing provider cites an insurance policy restriction in denying a request from a person with a disability to reside in a dwelling with an assistance animal that is of a breed of dog that the landlord's insurance carrier considers to be dangerous. If a housing provider's insurance carrier would cancel, subsequently increase the cost of the insurance policy, or adversely change the policy terms because of the presence of a certain breed of dog or a certain animal, HUD will find that this imposes an undue financial and administrative burden on the housing provider. However, this claim would need to be verified with the insurance company directly, and it would need to be considered whether a comparable insurance without the restriction is available in the market. If a HUD investigator finds evidence that an insurance provider has a policy of refusing to insure any housing that has animals without exception for assistance animals, it may refer that information to the Department of Justice for investigation to determine whether the insurance provider has provided federal civil rights laws prohibiting, has violated whether the insurance provider has violated federal civil rights laws prohibiting discrimination based on disability. And that concludes my presentation.
Well, Holly, thank you so much. That was fascinating. I did not know all those ins and outs about animals. I knew there were, support animals versus service animals. But boy, all of that case law is so interesting because you don't realize how many different kinds of, animals, whether it be dogs, snakes, monkeys, and all that. But it makes sense that sometimes people need that. Now, I could understand not wanting a tenant to come in to pay their rent with a big old snake draped around them.
Yeah.
That would bother me a little bit as a landlord. But it's interesting how that moved through the court system, and interesting that the court in that one case said, yeah, you've got to do the examination. You got to get through the elements of the direct threat thing. So I think that's really good, and particularly that last part about the insurance, I think, is so relevant because it looks like you can't really use that as an excuse.
No.
So that's a good thing. Well, it doesn't look like we have any questions, so you covered the topic masterfully. I do want to note for our viewers, whether you're live or on the replay, that you can scan that QR code on your screen and sign up for our newsletter, which is really great and full of all kinds of information. And we have a lot of resources here at South Carolina Legal Services, even beyond what we do every week here on Level Up Law. So I do invite you to check that out. You can email us, you can go to our website, you can see all that here on the screen. We are on all the social media channels for the most part, and there's all the handles right there. You can also just click on those from our website. But we have a lot of great resources, and that's where we get that information out to folks, whether it be through newsletter, website, social media. And of course, that's how we reach folks to join us for Level Up Law. And you can sign up to be on our email list through that QR code, and then you'll get information about the Level Up Law episodes on an ongoing, regular basis. So thanks, Holly, for an excellent presentation. Holly Webster, terrific housing attorney here at South Carolina Legal Services. And we really appreciate the Equal Justice Works housing justice program that provides the fellowships for us, for folks to help people the way that Holly does on a daily basis. She is always busy. She's up here in the Greenville office where I am, so I can certainly vouch for that. But thanks to our audience. We really appreciate you joining us here each week, whether it's live or on the replay on our YouTube channel. Appreciate you being here. And we want to tell everybody, if you find this helpful or you know someone who might be having this issue or some other issue that we've talked about on Level Up Law, hey, share out this broadcast. We're recording it. It'll be there on our YouTube channel probably this afternoon. And we want as many people as possible to get the important information that we are providing on Level Up Law. And while you're there, of course, we want you to subscribe to the channel so you can get more of this information. And, ring that little bell icon, sign up for notifications while you're there. That way you get a notification each week when we post an episode, just in case you missed it. So thanks, everybody, for tuning in, and be sure to tune in next week. Throughout the month of May, it's Older Americans Month, and that will be a focus for us on Level Up Law. But also, it's Asian American, Native Hawaiian, and Pacific Islander Awareness Month, and we'll be honoring that here at South Carolina Legal Services as well. So thanks again, Holly Webster. Thanks to our audience for tuning in today on Level Up Law. That concludes today's webinar. Thanks, everybody.